So just to cover the topic of privacy laws regarding data and imagery, I'll try to put a more practical spin on it from a practitioner who looks at intellectual property rights contracts from various organisations and working with our clients. The topics I'll cover is firstly personal information, which Andrew touched on in the previous talk, and the Privacy Act, data ownership and control, how best to understand who owns your data, image, map or database, data use and agreements, and data and innovation. In the context of data, imagery and privacy, I've divided the talk into two core groups, commercial information and personal information. So personal information and the Privacy Act. Privacy laws are focused on personal information, as Andrew touched on, and the laws around how that information is stored, used and distributed. So the key issue in terms of looking at data, imagery and maps and personal information is understanding what personal information is and what the laws dictate around personal information. So personal information is about the individual. That's the distinction. It's not about a business. It's not about the business where the individual works. It's not about business information. It is also about information that can be used to identify the individual, not the business information. And that information that can be collected about an individual is considered personal information if it is directly related to the individual or indirectly related to the individual. A simple example of indirect is a number plate can be linked to a person that owns that vehicle as indirect. Privacy laws are governed by the Privacy Act of 1998 and related state legislation. The key issue is businesses with a turnover of less than $3 million do not have to comply to the Privacy Act. So that's important to consider when you're looking at your service providers. So Privacy Act and personal information, the key message I wanted to give across, when you're collecting information from a commercial perspective, can it be used to identify an individual or can that individual be reasonably ascertained or identified from the information? If that individual can be identified, then you need to treat it as personal information and manage it as such. So privacy and ownership of data are separate issues. They shouldn't be confused. The privacy legislation does not consider ownership of the data itself. So now the talk to cover the more important issue, I suppose, for the audience is commercial information and collecting commercial information. The diagram here of, if you like, a real estate agent photo has been in the press, or in terms of a legal aspect, because drones were taking photos of real estate properties and were you allowed to do that from the Privacy Act, etc., who owned the photo, etc. That all came up in recent court cases. The key issue in this diagram here of the real estate photo is that there is no way to identify an individual in the photo. So would it be captured by the Privacy Act? Most likely not. So in terms of commercial information, again, for the context of commercial information can include a lot of different forms of information. For the purpose of the talk, I've just divided up into raw factual data and provided some examples here of raw factual data, then imagery and photography. So why I've divided it up, there are different rules or laws that govern factual information versus imagery and photographs. So understanding data ownership. The key messages that I'd like to give is from an intellectual property and person that studies and manages intellectual property for clients, is that in terms of raw data, raw factual information, there are no intellectual property rights that exist on data itself unless it is considered confidential information. So copyright laws protect the compilation of data, of raw data into a database, and but it does not protect the individual data in that database. So that's an important distinction. Raw data does not have any intellectual property rights unless it is confidential information. So when you see agreements come to you and say, we are going to assign you have the control and ownership of your own data, the legal basis for assigning raw data is questionable. So imaging, when you look at imaging and photographs, it's a different context. They are clearly protected by copyright laws, and there is a capacity to assign that or to give the ownership to the person under contract. But that is more difficult to achieve on raw data. So let's consider how ownership changes over raw data as it's converted to a useful form. Raw data is generally not very useful. It has to be converted to a useful form, whether that's a farm map or otherwise. So the key message is ownership changes as the form of information changes. And the ownership will go with the person creating that information or that new image, irrespective of who provides the data. So the service providers that you engage add value to the data that you collect. As a simple example in this diagram here, courtesy of PCT and Narrabri, they've converted the data from an image and corrected that data to be more useful for land management or for field management. So in the context of this and that conversion, PCT initially would own that converted data. So how do you determine who owns your data? From a contractual basis, it really depends on who's collecting and made the material. Are they an employee? Are they a contractor? Who owns the machine that, or the equipment that generated that data? So the key message is that ownership and rights does not exist just because you paid for the information to be collected. There is no implied assignment of data rights. It has to be a written agreement. So it's a good time to consider how you manage data ownership or imagery via contract. So contract or agreements provide you the right of control and access of data that may come from your property. You have to remember that they will provide you a right over control, but not the raw data itself when you're looking at raw factual data. So let's look at some typical case examples which we come across in managing and working with clients. So a typical question is, if you pay someone to collect data or image, do you have control over the material? If a contractor comes onto your property, do you own the material which they are collecting or collected by their machine, whether it's a UAV or a tractor or otherwise? If you pay for the data to be converted to a map or a more useful form, do you own the map or converted data? The answer to these questions is no, unless you have a contract in place that gives you ownership and rights to use. In terms of general use of the data being collected, there is an implied licence irrespective of written contract. There is an implied licence that you can use that data for your own purposes. The core question that we have about data is, if the agreement states that you will own data, does this prevent those from using and selling that data? So it's a typical question which we receive, and the answer is it depends. Depends on the contract which you're signing or did not sign. So in terms of the general principles and looking at contracts and the terms of which you should really concentrate on in terms of data, imagery, ownership and use, the general principles are the agreements that do not state how data can be used and shared will not prevent the use of that data for commercial purposes unless the information is protected as confidential information. Remember, there are no IP rights for raw factual data. So a typical example which we see and clients receive, where they would state that you shall own and retain all rights, title and interest to your data. And the agreement will go on to say that they will provide you a right of access and to withdraw the data from the database of what they're compiling. That's not a word I like, but the but. These agreements also include a clause where you grant the service provider, whoever that may be, a perpetual, irrevocable licence to access, use, reproduce and prepare derivative works based on your data. So what does all that mean in the context of what you're giving? It means that the service provider, or whoever you're signing this agreement with, can do just about anything with the data without your consent, without your knowledge, as long as they like. So remember, just because you have the right to factual data, you do not have the right in the imaging or the maps that are generated from that data unless it's been written down in a written contract. Another common clause very quickly is warranties. All these agreements will include warranties, where the service provider say you warrant that you're not, the data you're providing will not impede the rights of another organisation or individual. You need to be very careful about considering such clauses and in providing data. So on a more positive note, as the introduction, I'm a fan of technology and developing technologies and innovation. So data sharing is fundamental. It drives innovation. So the message I'd like to portray is, be proactive and more rather than reactive when you're considering your data management and data management agreements which are asked to sign. Just to give you an example, just a quick look at one of the services we provide is looking at innovation and the space of what companies are developing. This is just a graph showing the number of patents being lodged and granted in terms of two areas, precision agriculture and data management related to agriculture. So you can see there's quite a large number of patents even in the last 5 years around precision agriculture and data management. So the data management of patents are focused on data analytics and how data can be used, and these companies are developing patents to protect the way in which they're using and managing data. Excuse me. From an industry's perspective, this issue of data ownership and rights of use and consent is being looked at through by a number of industries. The Rural R&D for Profit project, which is funded by a number of rural industries and the federal government, is looking at identifying the data types and the information available as assets, the standards for sharing that data, and best practice agreements that should be followed by property owners and service providers. It is a hope that potentially a code of practice could be developed for data management. Similar standards have been developed in the US and in New Zealand. So just to sum up, the key messages is that privacy and information is managed by the Privacy Act. It does not consider commercial information. It's about the individual. And data ownership and control. No copyright protection exists over facts or raw data. Raw data and ownership is converted as that information is converted from a raw data to a useful form. We need to be proactive in the data management and looking at the agreements and data sharing. A fan of open source data creates innovation. So just a plug for my own company. We're based in Toowoomba. We've been there for 10 years. We focus on intellectual property management. We look at research and technology investments, IP protection and licensing, IP risk assessments, technology commercialisation. And we're starting up a new service around data management because of certainly the need for that. It's been recognised for that, a need for understanding service agreements that relate to data management. and please visit our website for more information there. And the last note is, in terms of the Rural R&D for Profit project, Associate Professor Leanne Wiseman is in the audience, I believe, and she's running a program under that project for industry, looking at laws that govern data management. So Leanne, if you'd like to stand up, wherever you are. If you'd like to have a discussion with Leanne or myself this afternoon, please welcome to do that. Thank you.